Estate planning. What is it and why is it important? Estate planning is very important for all involved: the deceased, the spouse, the family. After a person's death, his or her assets should be distributed according to the person's will and directions with little or no questions and problems. This is especially the case in California, where it is important to know the differences between wills and trusts when planning for estates. A will is a legal document that helps in the distribution of assets and properties upon death. It lets you nominate the person who will receive your properties, nominate guardians for your minor children, and state your last wishes. The absence of a will causes the intestate succession laws of the state to come into play and determine how your assets will be divided up. This can lead to a conflict among the family members, and the beneficiaries may not be who you, as the deceased, want them to be. Therefore, a will is important because it makes it easier to determine how your assets will be used according to your wishes and provides guidance to the people you leave behind. In addition to a will, you may want greater clarification for the executor by having a trust. A trust is a legal tool where a trustee holds and manages assets for the benefit of the beneficiaries. In California, the two most common types of trust are revocable and irrevocable trusts. Living or revocable trust: these are trusts that the grantor can easily change or even revoke while the grantor is still alive. They are versatile, and the grantor is in a position to keep on controlling the assets. The grantor's estate planning is completed upon his or her death, and the trust becomes irrevocable and the assets are distributed in accordance with the trust provisions. The main benefit is that for the most part, revocable trust assets do not go through probate, which means that the process of distributing assets is much simpler and less tedious and less costly, and far quicker to distribute the assets, and, in some cases, public. Irrevocable trusts: these are trusts that cannot be changed or terminated once they are created without the permission of the beneficiaries. They are usually used for estate planning and for legal reasons such as tax purposes and asset protection, because the grants made to an irrevocable trust are excluded from the grantor's estate for tax purposes and are not generally available to the grantor's creditors. But the grantor cannot keep full rights over the assets, which is an important factor that needs to be considered. Living trusts: a living trust is one that is set up during the lifetime of the settlor and may be revocable or irrevocable. Living trusts are commonly executed in California as an estate planning tool because they can help to avoid probate. It is possible to avoid probate by moving the assets into a living trust, where they will be controlled by the trust terms during the grantor's lifetime and after death without the need to seek court approval. This also ensures that the process is done in private and also facilitates the smooth movement of assets to the respective beneficiaries. Also, the living trusts are flexible in the management of the assets, since the grantor can make changes in the trust as the circumstances demand. In conclusion, it is crucial to comprehend the functions and advantages of wills and trusts in California. Although a will enables you to determine how your properties will be distributed after death, and nominate guardians for your children, the latter offers such benefits as avoiding the probate process, preserving the anonymity of the process, and managing assets with more flexibility. An estate planning attorney can give you an idea of what is the best strategy for your case. I know two great estate planning attorneys. Send me a text and I will share their names and numbers.